taken to have disruptive individuals removed if their continued presence poses a safety risk to the others in the room or makes it impossible to continue the meeting. Juan, would you like to do introductions and roll?
When I call on you, please state your name and who you represent for the record. Please start with you, Chair Fletcher.
I'm Mike Fletcher. I'm with Oregon Emergency Management representing Oregon APCO-NENA.
Thank you. Member Boren.
Mark Bourne, public member, CCP.
Thank you. Member Cron.
John Frost, corrections officer, AFSCME's non-management represented staff.
Thank you. Member Griffin.
Hi, Rhonda Griffin, LeGrand Police Department, representing APCO-NENA, the TPC committee.
And Member Wood.
Robert Wood, public member for the Police Policy Committee.
And now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Erica Dell, Criminal Justice Support Specialist, DPSST.
Cindy Park, DPSST.
Marie Atwood, DPSST.
Jennifer Howell, DPSST.
Ben Hamilton, DPSST.
Thank you, Chair.
Thank you. So at this point, we are looking for consensus to approve the meeting minutes. Has the committee had a chance to review those minutes? Is there a need to edit them, change them, reject them? If not, I'm looking for some kind of sign, thumbs up, that we have a consensus. Very good, and we can consider the meeting minutes approved. We're ready to jump into standard case review. So we're going to start the process. We are changing the agenda up a little bit in the order of cases heard. For the person who will be providing testimony for mitigation, it's a little bit challenging when we do this hybrid. We do have a clock here. You're given 5 minutes, and because it's hybrid, it seems a little awkward. When that time is up, we'll try and give you a high sign that we're getting close, but it's also a possibility that you will just be cut off. So with that, I'm going to introduce Ms. Park.
Anthony. We're doing Anthony Mazzola.
That's, yes, we can do that.
Okay. Cindy Park for the record. The first case being reviewed is Anthony Mazzola. A case was opened by the department after receiving an application for training and a criminal history reporting form in which Anthony disclosed previous criminal dispositions. Anthony was arrested on May 14th, 2021 in Roseburg, Oregon for the offenses of reckless driving, recklessly endangering another person, and failure to perform the duties of a driver after he was observed driving, speeding down a residential street with his light bar on and stopping with the light bar, pointing directly at a witness home, getting out of his vehicle and yelling at the witnesses, and later hitting another car. On June 21st, 2021, Mazzola pled no contest to the charge of reckless driving and entered into a 6-month diversion agreement, which he completed in December of 2021. The rest of the charges were not, they didn't go forward with. The department found sufficient evidence for the following moral fitness violations: dishonesty. Mazzola was dishonest when he denied hitting a vehicle, stating to police officers that the paint transfer on his vehicle probably came from parking on the street. Gross misconduct. Mazzola engaged in gross misconduct when he drove his vehicle down a road with the light bar on and swerved toward pedestrians, which could have caused significant harm to individuals or property. And Mazzola engaged in gross misconduct when he intentionally hit another vehicle, causing damage to the vehicle. Chair Fletcher.
Thank you, Ms. Park. Mr. Mazzola, you will have 5 minutes. A reminder to the committee members, it's the subject's time, and so no questions will be asked by the committee. Mr. Mazzola, if the clock is ready, I'm sorry, Erica, ready? So the time is yours, sir.
Yeah, so during the incident in 2021, as far as swerving down the street and stuff, and hitting the other vehicle, I was truly in fear for my life of what was going on. There was multiple people coming at my vehicle, looking to batter my vehicle, batter me. And when I got to the other vehicle, he was threatening me with a cinder block, grabbing it, potentially throwing it at my head, as I had my window down. So I was reaching for the gear shift. I didn't recall hitting the vehicle at that time. And, in later timing, when I was starting to kind of become clear-headed, did I actually realize what had happened and what was going on. I had multiple incidences with these guys, as I lived fairly close to them. And multiple times I reported it to the local police department, but nothing had been done. It was just word against word. And then this incident had happened. But like I said, I was truly in fear for my life as far as what was going on. With that being said, for me it was 4 years ago. It was a long time ago, and for me, I've grown a lot since then. I've done the local police reserve academy here to, become a law enforcement officer. I was successful with that, completed that, and graduated from that. I've gotten married. I moved out of Roseburg into Winston, which is fairly close, but I don't have any contact with those people at all anymore, nor do I see them ever. We bought a house. I have a lot more responsibilities than I did previously. So I've grown quite a bit since then. I knew this was going to affect me being hired on with the sheriff's office, and that's why I was so honest about everything that was going on. I disclosed everything to them as it had happened. So with all that, I'm also getting it expunged, and in the process of getting it completely expunged from my record. OSB has gone through the processing part of it. I should hear back by the end of this month, first week of January, as far as getting it completely expunged. I recognize now, being employed for a few months with the sheriff's office, I recognize the escalation in situations and how to de-escalate them from working in our jail, and now I confidently can say that I can do those. Still learning a lot. I've only been in the jail for a couple months, but I can definitely recognize those situations. I've taken numerous steps to make sure things like this won't ever happen again. The big one is completely moving out of the town. I've never had direct contact with them after that incident. Doing the PRA, kind of advancing my career in law enforcement, has been a big thing for me. Now I'm putting everything I have into making law enforcement my end goal career with the sheriff's office here. And so I value my career here and everything I'm learning. Moving forward, I just hope, this can be my end goal, whether in the sheriff's office, whether it be in the jail or out on patrol or wherever that is. Yeah, I'm finished. I don't have anything else to say.
Very good. Thank you, sir. So at this time for the committee, we're just reviewing the report and records and making sure that they are complete, and we're looking to adopt the record as presented, or if need be, to return it to staff. So I'm looking for consensus. This does not require a vote. So thank you. This is excellent. We can adopt the record. Thank you. Moving on to discussion of aggravating and mitigating factors. This again is by consensus, but we open up the case for discussion. Remember to state your name and if you're identifying aggravating or mitigating factors. The floor is the committee's.
Rhonda Griffin for the record. So I think mitigating is he does have the support of, it looks like his department, they did hire him knowing his background. And for him to appear today means a lot, to say that, yes, I made a mistake. I think aggregating for me is the time. I know he said it 4 years is a long time, but really to me, that's not a long time. And then also in his letter, he says that he did not recall striking the other vehicle, but then later regained a clear recollection of the events. I think if I was to have struck a vehicle, I would know. So I'm a little concerned about that statement, that he kind of changed his story or was trying to, come up with a plan, I guess, or an idea of why he did it.
Thank you, Rhonda.
Robert Wood for the record. Additional mitigating is the letters of support. And his admitted additional training on de-escalation. And back to aggravating, I too have a problem with the honesty part of it. And I too agree with committee member Griffin that I find it difficult to not recall hitting the vehicle twice, and then the report that the officer provided is clear that they did collide, the same height, same paint transfer. And I too have struggled with it only being 4.5 years, when some of the letters of support says they worked with him for 6 years and find him totally outstanding and honest and high moral fitness.
Thank you, sir. Mike Fletcher for the record. Mitigating, I appreciate Mr. Mazzola's presence here today. His statement was compelling. I appreciate the skill sets that he's learning working for the sheriff's office. He's taken steps to remove himself from potential future conflicts with the parties. While I appreciate his time frame, thinking 4 years is a long time, if you're in this career for 30 plus years, that 4 years is a blink. And so we do in public safety look at things, and that's a fresh event for at least for most agencies. I too struggled with the changing of the story at the time, and that will conclude my input. Any other comments from the committee members?
Robert Wood for the record. I'm looking through the record that I don't see anywhere that, today was the first time I heard that in fear for my life because they had a cinder block, and I could be missing something. Members, please correct me if I'm wrong, where it was before some kind of weapon in their hand. So I think that's a discrepancy of recollection.
Noted.
John Frost for the record. In his mitigating letter, he does say that he was attempting to avoid being struck by blunt objects directed at me and his vehicle. So it's in the record at least.
Cindy Park for the record. In the police report, he did mention something about feeling that one of the witnesses had some sort of weapon in their hand. It wasn't specific as to what.
Yes, I recognize that, and Robert Wood for the record, I'm just questioning now that it's a cinder block where it wasn't defined before. Thank you.
If there's no other input, Ms. Park, would you review the mitigation and aggravating factors?
Aggravating, several people mentioned that it was not a long time ago, only 4.5 years. The statement that Mazzola did not recall striking the vehicle at the time, and despite the police report showing evidence to the contrary. And That is all I have for aggravating. I don't know if I missed anything. For mitigating, he has the support of his department. Mazzola appeared today to provide verbal testimony and it was compelling. The letters of support that were in the packet, the additional de-escalation training and other training that Mazzola has undergone, and he's taken steps to remove himself from the conflict. Chair Fletcher?
Thank you. At this point, we move to discussion about the moral fitness violations. This is requiring a motion and a vote. Remind members to state your name for the record and identify the moral fitness findings identified in the staff report. Your options are affirm, accept as is, modify to make changes, or negate to remove all. Open. Thank you, sir.
Robert Wood, for the record, I move that we adopt, accept the staff report with the moral fitness violations as presented.
It's been moved. Is there a second?
I'll second that.
Support.
John Frost for the record.
It's moved in second. Any further discussion? Erica, call for the vote.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Fletcher?
Aye.
Committee Member Boren?
Aye.
Committee Member Frost?
Aye.
Committee Member Griffin?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
We are at the point to listen to the committee on your desire to take action or no action. Again, this is a motion and a vote.
Robert Wood, for the record, once again, I'm going to ask the question I ask quite often. If we take action, what is the time period, the minimum and maximum time period for each of the moral fitness violations? And when does it begin?
With Cindy Park, for the record, in the applicant review committee, the time that you can take action is up to 10 years. And it would begin on June 21st, 2021, when he pled no contest to the charge. So that's his position.
21.
Mhm.
And what's the minimum time?
I think it's 0 to 10 years.
Even for dishonesty?
Yes.
Thank you. Thank you. Robert Wood, for the record, I recommend, or I make a motion that we do take action.
Rhonda Griffin for the record, I'll second that.
Moved and seconded. Any discussion? Hearing none, call for the vote.
We are voting on a motion to take action. Chair Fletcher?
Aye.
Committee Member Boren?
Aye.
Committee Member Frost?
Aye.
Committee Member Griffin?
Aye.
Committee Member Wood?
Aye.
Motion passed.
Since we've taken action, now we need to determine the ineligibility period. This too requires a motion and a vote. And as Ms. Park mentioned, the options to the committee is a time frame of 0 to 10 years. Any action taken regarding certifications would begin June 21 of 2021. The committee has the floor.
Rhonda Griffin for the record. I think that, taking everything into consideration, I would recommend 3 years.
Robert Wood, for the record, I too support a lesser time period. We do need to recognize as a committee that there was moral fitness violations and concerning moral fitness violations, by the way, and they were only 4.3 years ago. So I would support also a time frame like that.
So is that a second, sir?
Was that a motion?
That's a fair question. Ms. Griffin, was that a motion or just a point of
Yeah,
discussion?
no, sure, that could be a motion.
Robert, for the record, I second that motion.
Okay. Thanks for the teamwork, folks. It's been moved in second. Any further discussion? Hearing none. Call for a vote.
We are voting on a motion for a 3-year ineligibility period. Chair Fletcher?
Aye.
Committee Member Bourne?
Aye.
Committee Member Frost?
Aye.
Committee Member Griffin?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
So, Ms. Park, from this point, we provide Mr. Mazzola instructions of what that really means?
Yes,
Okay.
yes. Mr. Mazzola, I'll send you an email and we'll have a chat about those documentation.
And that closes that case?
Thank you very much.
Just change my paperwork here. So now we're going to Mr. Taylor, is that correct?
Yes, he's here.
Okay. At this point, she'll present the next case, which is Davon Taylor.
Cindy Park, for the record, the department received an application for training and criminal history reporting form for Davon Taylor, in which Taylor disclosed previous criminal dispositions. On February 19th, 2017, Taylor was cited for the offenses of DUI, reckless driving, and recklessly endangering another person after an incident in Polk County, Oregon, involving a 2-vehicle crash. Taylor showed several clues of intoxication during standardized field sobriety tests and provided a breath sample with a resulting BAC of 0.11. On April 17th, 2017, in Polk County, Taylor pled guilty to the offense of driving under the influence of intoxicants and entered into a diversion program. On April 21st, 2017, Taylor pled guilty to the offense of recklessly endangering another person, a misdemeanor. Moral fitness violations. The department found that Taylor violated the board's pre-employment moral fitness standard for gross misconduct when he chose to drive a motor vehicle on a public roadway while under the influence of alcohol, resulting in a collision with another vehicle. His actions caused significant damage to the vehicles involved and could have caused significant harm to himself and others. The department did not identify sufficient evidence to support a finding of dishonesty. Chair Fletcher?
Thank you. Mr. Taylor is
Yes.
via video. Yes, sir. So we're going to allow you time to speak to the committee. You have 5 minutes, and the same rules apply. The committee is not allowed to ask questions. There is a clock here. Again, because it's hybrid, it's a little challenging, but we'll give you the 5 minutes. We'll try and give you some kind of visual clue, waving of the hands that you're approaching the end of your time. If not, it could be possible that we just cut you off. And if you're prepared, Erica, are you prepared with the official timekeeper? Sir, it's your time.
Alrighty. So good morning, everyone. Thank you for being here. Thank you for having me. In February 19th of 2017, the facts here are stating that I had a DUI, endangering another person as well. 8 years ago, I was definitely a different person than I am today. I wasn't a father of a 4-year-old. I didn't have the ambitions that I have right now in this career that I've actually found a good home in over here in Eastern Oregon that I've relocated to from the other side of the state where I used to work there. I also have stopped drinking since then. I just didn't really see it aligning with the goals that I have for myself in the future. Looking forward to being married and trying to purchase some land in this area. I enjoy now just building my cars and working with my horses and just continuing to grow the family and just strive for trying to be a better person that I just didn't really have the tools and idea even that I was capable of being today. So I don't need the full 5 minutes again. I thank you guys all for being here.
All right, thank you, sir.
Thank you.
It's time for the committee to determine whether to adopt the record as presented. And this is a consensus. And so I'm looking for some thank you, and thank you. This is going very well. So we can adopt the record. Thank you. At this point, we're going to discuss aggravating or mitigating factors. Again, this is by consensus, but we open the case for discussion. Remember to state your name for the record. And then if you're identifying any aggravating or mitigating factors, the floor is to the committee.
So Rhonda Griffin for the record. So mitigating would be that he did appear today. And it looks like this incident did occur, like he said, 7 years ago. It looked like in looking at the documentation we have, there was a rough patch there of about 4 years, between 14 and 17. But it sounds to me like he's getting his life together, which means a lot. And I think aggravating was just that the severity of what he did, a head-on crash could have killed somebody. We've had many, many of those in my career here, and that would be an aggravating event for me. And that's it.
Thank you,
With additional mitigating factors is a good letter of support from a person in Tillamook, and the fact that DOC has picked them up, knowing the backgrounds.
the gentleman, Mr. Taylor's being present and testifying on his own behalf today. That's mitigating as well as his letters of support and obviously being hired by the Department of Corrections. Aggravating, as mentioned, the incident in question is concerning. I also have concern about honesty. If I read his reports and the entire packet correctly, DPSST discovered through paperwork, I believe, that Mr. Taylor did. When specifically asked in the ESOF software of any detainment, arrest, conviction of theft. And I believe I read where he was suspended. He was caught driving while suspended twice. And that's not a part of his record. And so I appreciate staff here identifying those things. I have a question for staff regarding the front page of your report, dishonesty. The department did not identify elements of dishonesty. But when reading from the DOC's background investigator, they too agree that he did not disclose those contacts with law enforcement.
Rob Wood, for the record, if I can interject, I found the same thing, but on the F-28, his application to attend DPSST, he did disclose all those.
Correct.
Which I don't know about the timing for such. Do you get hired first with DOC and then you apply to attend academy?
Yes. Mike Fletcher for the record, yes.
Okay, thank you.
Cindy Park, for the record, regarding the dishonesty, I didn't feel like I had enough because I had the information and I couldn't find any, there were no police reports or any other information to be had. I didn't feel that I had enough direct information to make that particular statement of dishonesty.
And I read that too. I saw the back and forth with agency in California. There is a record, but they don't have any, they've deleted those records because of age.
Since it's 2005,
Right,
it's been removed from the
destroyed.
records.
Correct. But the fact of the matter to me personally is that it did take place, and while he reported to TPSST, he did not report it to DOC throughout the entire hiring process, and I have an issue with that. That concludes my input.
Rob Wood for the record. Additional aggravating, which is kind of been mentioned, is we get cases all the time with an intoxicated driving conviction. But there's a concerning pattern of behavior here, first with the theft and then driving while suspended twice, but also upon the DUI arrest, that was also suspended driver's license. That's it for now.
Any other input from the committee members? Hearing none, Ms. Park, would you read back?
Aggravating the severity of the incident and that it was a head-on crash. I'm sorry, Cindy Park for the record. And concern regarding the previous charges in 2005 for dishonesty and driving while suspended reported to the department but not to the Department of Corrections. Mitigating, Davon appeared today and provided verbal mitigation that was compelling. The incident was over 7 years ago, and he's shown that he's gotten his life together. And there are letters of support provided, which are mitigating, and the Department of Corrections employed Davon knowing his history. Chair Fletcher.
Thank you.
I'd like to add another mitigating. He did complete a diversion successfully, and I don't think we mentioned that.
Did everybody in the committee hear that? And Ms. Park is adding that to the record. Thank you. So we open up for discussion about moral fitness violations by motion and vote. Your options are affirm, modify, or negate. Again, state your name for the record, and the floor is yours.
Robert, for the record, I'd like to discuss more of your chair's opinion of dishonesty. And I look at dishonesty sometimes with what's the benefit and the intention. And if he intentionally left that off the application with DOC, knowing maybe that the records were deleted, then I would think he would do the same thing with the DPSST F-2028. That's just a point of discussion. And I support staffs that they didn't have enough to find dishonesty.
Mike Fletcher for the record. I agree with Mr. Wood, and I understand DPSST's challenge with that. As far as intent, I struggle with that as well. And it is confusing for a person to admit it to one agency or one party and not the other. That's interesting. Any other input from the committee? Hearing none. So again, we're looking for a motion and a vote to affirm the moral fitness violations, modify, or negate.
Rhonda Griffin for the record. I've motion that we affirm the moral fitness violations.
Thank you, Rhonda. It's been moved. Is there a second?
John Frost for the
Mark
record, I'll
Bourne for the
second
record.
that.
We'll take one of those. We'll take Mr. Frost because I recognize that. So it's been moved and seconded. Is there any further discussion? Hearing none. Erica, call for the vote.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Fletcher?
Aye.
Committee Member Boren?
Aye.
Committee Member Frost?
Aye.
Member Griffin?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
So at this point, we're going to take a motion and a vote to take action or no action. If we're taking action, the party should include why and the same for no action. Again, I turn it to the committee.
Rhonda Griffin for the record. I will motion that we do take action. And I think just due to the number of incidents and the potential for being untruthful.
Thank you, Rhonda. Is there a second?
Mark Bourne for the record. I'll second that.
It's been moved in second to take action. Is there any further discussion? We'll call for the vote.
We are voting on a motion to take action. Chair Fletcher?
Aye.
Committee Member Boren?
Aye.
Committee Member Frost?
Aye.
Committee Member Griffin?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you, Erica. So at this point, we're going to determine the period of ineligibility. This is again a motion and a vote. The timeline is from 0 to 10 years. And this will be a good test question. Ms. Park, when would the initial time begin?
Cindy Park for the record. Chair Fletcher, the initial time would begin on April 17th, 2017, when he pled guilty to the offense.
Did everybody in the committee hear that? April 17, 2017 would be the start time of an ineligibility period. And I'll open it to the floor.
Rhonda Griffin for the record. I would recommend 5 years ineligibility. And I think that's just due to the severity of the head-on crash. Because that is concerning to me.
Thank you. There's a motion on the floor. Is there a second?
John Frost for the record, I'll second that.
It's been moved and seconded to impose a 5-year of ineligibility. Any further discussion? Hearing none, call for a vote.
We are voting on a motion for a 5-year ineligibility period. Chair Fletcher?
Aye.
Committee Member Boren?
Aye.
Committee Member Frost?
Aye.
Committee Member Griffin?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
At this point, I turn it back to Ms. Park. You'll be contacting Mr. Taylor.
Yes. Cindy Park for the record. Mr. Taylor, I've sent you an email and I'll follow up in a conversation with you regarding this.
Okay, that case is closed. The next case up for discussion and consideration is Taylor Babb. Ms. Park.
Cindy Park for the record. The case was opened by the department after receiving an application for training in a criminal history reporting form regarding Tyler Babb. On April 20th, 2020, Babb was cited for 2 counts of unlawful taking of a goose closed season after harvesting 2 Canadian geese out of season with a rifle along the North Fork of the John Day River. In July 2020, Babb pled guilty to 1 amended charge of taking, angling, hunting, or trapping in violation of wildlife law or rule violation of wildlife law with culpable mental state, which was reduced from a misdemeanor to a violation via DA election. Mr. Babb was ordered to pay a fine, and the second charge was dismissed. Gross misconduct was found by the department in that Babb's actions, which led to the criminal disposition, harmed the property of the state of Oregon and its wildlife resources. Chair Fletcher.
Thank you. And if I'm correct, Mr. Babb is not present?
He is not.
Okay, thank you. For the committee, we're going to ask for consensus to adopt the record or return the case to staff if additional information is needed. This is a consensus. Looking for a positive or negative sign. Look, 2 thumbs up, 3. Thank you. The record has been adopted. At this time, we're going to discuss aggravating and mitigating factors. Again, this is a consensus. We'll open up for discussion. Remember to state your name for the record and then identify the aggravating or mitigating factors.
Rhonda Griffin for the record. I think mitigating for me is he was honest throughout the interaction with the state trooper. He was remorseful. I believe he indicated that he hadn't eaten in 2 days. He was so worried about the situation. Mitigating, of course, was just the action. He knew it was wrong, but yet he did it anyway. And that's what I have.
Thank you. That last one was an aggravating. Yep. Thank you. Any other input?
Mark Bourne for the record. Even though he didn't appear today and give verbal testimony, he did in his letter take full responsibility for his actions and owned up to his mistake. And went on talking about how he learned from the incident.
Thank you.
And Robert Woodford, Litigation, he has been picked up with you until his office. Knowing his background.
Sir. Any other input? Ms. Park?
Okay. For aggravating, the only thing that I recorded is that Babb knew what he did was wrong and did it anyway. For mitigating, he was honest in his interaction with law enforcement, appeared remorseful. He provided written mitigation in which he took responsibility for his actions, and the Umatilla County Sheriff's Office hired Babb knowing the background. Mr. Fletcher.
Thank you. Can I get confirmation consensus that the identifying factors have been identified? Thank you. And now we'll move to looking for a motion and a vote for discussion of moral fitness violations. Again, our options are affirm, modify, or negate.
Rhonda Griffin for the record. I would pass a motion or submit a motion to affirm the moral fitness violations.
Thank you. There's a motion to affirm. Is there a second?
Robert Wood for the record, I will second that.
It's moved and seconded. Any discussion? Hearing none. Call for the vote.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Fletcher?
Aye.
Committee Member Boren?
Aye.
Committee Member Frost?
Aye.
Committee Member Griffin,
Aye.
and Committee Member Wood.
Aye.
Motion passed.
This time, we'll looking for a motion and a vote to take action or no action. Again, state your name for the record and please include why you would like to take or not take any action. Open to the floor.
Okay, Robert Wood for the record. I'm gonna make a motion that we take no action based on, first of all, in my opinion, the low severity of the crime. Crime is a crime, I do admit that. But he took full ownership. That was brought up during the mitigating and I think he was glad, I think, when he finally got contacted by law enforcement. Like someone said, he couldn't sleep forever and he was hoping to get this over with. And his letter of that he submitted for mitigation, I think, goes a long ways. I think enough time has passed on this situation that, again, I'm going to make a motion for no action.
Rhonda Griffin for the record, I'll second that.
Moved and seconded to take no action. Any further discussion? Call for the vote.
We are voting on a motion to take no action. Chair Fletcher,
Aye.
Committee Member Bourne,
Aye.
Committee Member Frost,
Nay.
Committee Member Griffin,
Aye.
and Committee Member Wood.
Aye.
Motion passed.
Thank you. That case is closed and we now move on to inquiry closure memos, this part.
Cindy Park for the record. DPSST closed 4 inquiry closure into the pre-employment criminal conduct, and that was detailed in the attached memos. The documents are provided to the committee for informational purposes only, as the Oregon administrative rule has given DPSST the authority to close these inquiries without committee approval.
Thank you. We don't have an agency report, but if there's anything good of the order that the committee would like to discuss. Hearing none, our next committee meeting will be held on January 21st, 11 a.m. And for everyone, I hope you all have a good and safe holiday. We will adjourn the meeting.
Bye.